I'm sitting in the back of a bustling courtroom, my heart pounding so hard I can feel it in my ears. The judge's gavel has just come crashing down, and there's an air of electric tension mixed with a slight tang of fear drifting through the room. To my left, my best friend Wyatt squeezes my shoulder in a show of silent support, while on my right, my older sister Eden wipes away tears that keep threatening to smudge her careful makeup. At the front, the group of people who never thought they could be held accountable, representatives from the local Homeowners Association, stand with their attorneys looking utterly stunned. They never anticipated that I would push back, not after all the intimidation and legal threats they'd slung my way over the past year. Yet here I am, prepared to reveal every misdeed and overshadow every carefully concocted lie they used to strip me of my family's farmland rights. Watching them squirm before the entire court brings me both relief and a newfound determination. But let me tell you how we reached this point, because it all started one crisp morning that felt like any other. Back then, I had no clue that I'd be drawn into a showdown bigger than anything I'd ever experienced in my life. I grew up believing that my family's farm in rural Pennsylvania would always remain a haven of peace. The place had belonged to my grandparents before it passed to my father, then to me. It was a sprawling parcel of rolling fields, dotted with patches of wildflowers and centuries-old oak trees that shaded the back acreage. Neighbors were sparse and kind, and most folks respected boundaries. I spent my childhood building forts in the barn, collecting fresh eggs before school and watching late summer fireflies flicker against the twilight. Every memory was painted with a sense of belonging and stability, as though nothing could disrupt these roots that ran deep into the earth. Our land wasn't just property or real estate. It was the center of our family's history, the embodiment of our shared dreams. By the time I turned 25, I'd grown used to the rhythms of farm life. Early mornings feeding the chickens, midday checking on the orchard for pests, late afternoons repairing old fences. While other kids from my high school went off to big cities, my heart pulled me home. I took over daily operations after my father's health began declining. Though we struggled financially at times, the sheer joy of nurturing animals and crops outweighed the hardships. Whenever I stepped onto the soft soil and breathed in the mix of cut hay and fresh air, I felt both grateful and grounded. That sense of grounding shattered the day I spotted a shiny black SUV crawling up our unpaved driveway. It was late spring, warm enough that I was dressed in worn jeans and a dusty t-shirt, sweat dripping down my neck. I recall standing there, pitchfork in hand, feeling a strange tingle in my gut. At first I thought maybe a lost tourist was stopping for directions, but as soon as the driver got out, an impeccably dressed man with crisp khaki pants and a collared shirt, I sensed something else was at play. He introduced himself as a representative from the local Homeowners Association, a phrase that made no sense to me. Our farm wasn't part of any subdivision, nor had we agreed to any homeowners group. Politely, I told him so. He smiled, something self-assured and slightly condescending in that smile, and said he'd be back in touch with some documents I really ought to look into. I remember watching him drive off, dust swirling in the vehicle's wake, baffled at the idea that an HOA could have anything to do with us. Later that week, an official-looking envelope arrived in my mailbox. A single sheet of paper explained that a new housing development had cropped up near the farmland's boundary, bringing with it a powerful HOA. Because of newly enacted county zoning revisions, the letter claimed, my property might fall under the association's jurisdiction. Even more startling was mention of a plan to build a sprawling clubhouse and recreational facility, partially on the farmland I rightfully owned. They suggested we merge into their domain for the sake of community improvements, and gave me a phone number to call with questions. It was surreal. Nobody had even approached me about wanting to purchase a portion of land, nor had they asked my permission to build a clubhouse. It felt like a veiled threat hidden behind legal jargon. My father shook his head with an air of weary resignation. He'd heard of such developments in other states, where HOAs tried to absorb older properties, but neither of us believed it could happen here, not without our explicit consent. We decided it was likely an error or some misguided attempt at expansion that would be sorted out once we showed them our land deeds and documents. With that in mind, I phoned the number. It took me 2 days to get past various front desk people and community liaisons, each insisting on transferring me to someone else. Finally, a woman named Andrea came on the line. She spoke in a clipped tone, explaining that the new development's board of directors sought to create a state-of-the-art facility, including a pool, tennis courts, and a community center. Since my farmland abutted their property line, the HOA believed it fell into a freshly drawn municipal map. It's standard procedure, Andrea insisted. The new boundaries incorporate your acreage into our extended plan. My protests about being an independent farm, about having no interest in joining an HOA, were met with polite, scripted responses. That conversation ended on a note of unresolved tension, and Andrea promised to escalate my request. Days turned into weeks, and I heard nothing more. I carried on with my farm duties, half hoping the entire issue would disappear. But one Monday morning, I woke up to the low roar of machinery on the east side of our land. Alarmed, I hopped onto my ATV and drove out to find a crew of surveyors unrolling bright orange tape, placing stakes in neat lines through my fields. When I demanded to know what they were doing, they showed me documents that supposedly authorized them to map out the future site of the clubhouse. They claimed the HOA had every right to proceed, per county permissions. My anger flared. This was my family's land, not some vacant lot they could carve up to their liking. Enraged, I told them to leave immediately, or I'd be calling the sheriff. Their foreman shrugged and pulled out his phone. Whether he was calling the sheriff or his supervisor, I didn't know, but the next thing I heard was a threat. If you disrupt this legally sanctioned survey, the HOA can file an injunction. My mind raced. Could they really do that? I'd never dealt with such a bureaucratic mess before, and my father was too ill to handle the stress of it, so I took my frustration out by photographing every stake, every piece of equipment, every license plate. Then I escorted them off the property under the promise that we would fight this. Even as they drove away, they left half their fluorescent markers jammed in the ground. Deep inside, a sense of dread took hold. I tried calling the county offices to clarify the zoning boundaries, but phone tag and red tape greeted me at every turn. Finally, I got a single statement from an overworked clerk. According to the updated town plan, your parcel may now be considered part of the expanded residential zone. The clerk had no further details and suggested hiring a lawyer if I wanted to challenge it. Hiring a lawyer meant expenses we couldn't easily afford, but I realized I might have no other choice. It didn't help that flyers began appearing around my fence line a few days later, glossy, full-color brochures showing an artist rendering of a pristine building, tennis courts, picnic areas, and a pool. In one corner of the image, ironically, was a stylized barn, clearly referencing my property. I was furious and, if I'm honest, also afraid. How had it come to this? The brochures touted the phrase, "coming soon to serve our growing community." There was no mention that the growing community had not even asked permission to use the farmland they were banking on. I confided in my childhood friend Clara, who worked as a paralegal in a nearby town. She took one look at the brochures and the letter from the HOA and said, "This isn't just a misunderstanding. They're pushing to incorporate your farm." She recommended I gather all my property records, the deed, any historical documents, tax statements, and consider retaining legal counsel. HOAs can be ruthless, she warned. They thrive on the assumption people won't fight back. A sour feeling churned in my stomach. It wasn't just me on the line, it was my father, our animals, and the future of a farm that had been in the family for generations. Clara linked me with an attorney named Roland, who specialized in property disputes and had a particular dislike for overreaching HOAs. When I presented everything to him, he leaned back in his leather office chair, tapping a pen against his notepad. "I've seen cases like this," he said. "The association claims the county's new zoning laws allow them oversight, but your farmland could have historical protections. The key is discovering if your property was ever set up under certain agricultural or homestead exemptions." That was the first bit of hope I'd felt in weeks. Roland explained that if we could prove the land was historically exempt, or if the county had incorrectly redrawn the lines, we might have grounds to block the HOA's entire plan. However, none of that would matter unless we acted fast. Once the HOA broke ground, it would be much harder and more expensive to stop them. So I gave Roland the green light to investigate. Meanwhile, I tried to keep the farm running smoothly. My father, who was dealing with heart problems, kept telling me to focus on the orchard and the livestock, to leave the legal fight to Roland. But I knew ignoring the situation wouldn't make it go away. Late at night, I pored over ancient filing cabinets in our attic, searching for any scrap of paper that might prove we were exempt from forced rezoning. Old land surveys, handwritten notes from my grandfather, receipts for tractor repairs from decades ago. I sifted through them all. The unrelenting worry gnawed at me. Every time I heard a car approach, my heart skipped a beat, expecting more HOA nonsense. In the middle of that stressful summer, a second black SUV pulled into my driveway. Out stepped a woman who introduced herself as the president of the newly formed association board. She extended a handshake I hesitated to take, then stepped back and surveyed the farm with a glint of eagerness in her eyes. "Beautiful land," she commented. "I see why our members would love a facility here." Her words were polite, but her tone dripped with entitlement. I told her plainly that we had no intention of selling or leasing any portion of our property. She responded with a carefully rehearsed line. "We'd compensate you fairly, and the community would benefit from modern amenities." She might as well have been describing a business transaction for a vacant plot. We were at an impasse. She left, reminding me that the HOA had legal counsel ready in the event of any resistance. Roland's initial findings came back inconclusive. The property had been in my family for almost a century, but the specific agricultural exemption that might have once existed was never renewed after the 1980s. My grandfather had let it lapse, likely not anticipating modern sprawl. That meant the HOA's claim to rezone it under a broader residential plan wasn't automatically void. Still, Roland wasn't ready to concede defeat. "This is going to be a fight," he told me. "They're leveraging county regulations in their favor, but let's see if we can find a procedural flaw or a contradictory bylaw. Sometimes HOAs overreach and slip up." We began preparing for a possible legal showdown, gathering local support from neighbors and former farmhands who could vouch for our law. That's when the intimidation tactics escalated. I started receiving official-looking notices tacked to my fence post, warnings about violation of community standards, notices of failure to maintain landscaping, and even a threat of fines if I didn't repaint my barn in compliance with approved color palettes. At first, it would have been laughable if it weren't so unsettling. The nerve of this HOA to treat me as if I were already under their domain. I showed each notice to Roland, who told me not to respond to any of them except through our legal channels. But the more they piled up, the more ominous they felt. Did the HOA think burying me in petty regulations would break my will? The final straw came one crisp morning in early fall. The orchard's apples were nearly ripe, and I'd gone out to check for any windfall overnight. As I turned the corner past the old tractor, I saw a sign hammered into the ground near the orchard's edge. "Future home of Harvest Hills Community Clubhouse." My blood turned to ice. They had rebranded their project with a cute name, Harvest Hills, making it sound so bucolic. The sign bore an image of a polished building with a grand glass-fronted lobby, cartoon families splashing in a pool, rows of trees that might pass for decorative landscaping. A stylized version of my barn sat in the backdrop as a quaint relic. Outraged, I ripped the sign out of the ground and marched straight to the phone to call Roland. "They've officially staked their claim," I told him, voice shaking. "We have to do something now." He filed for a temporary restraining order to halt any construction or survey work until we resolved the property dispute. The local judge scheduled a hearing. Word spread through the township like wildfire. Some residents of the new development sided with the HOA, believing a modern facility would enhance their property values. Others, including longtime locals who recognized my family's contribution to the area, offered their support. I discovered that a few farmers in adjacent counties had faced similar battles. Some had lost, some had won. The outcome often hinged on legal minutiae. The question tearing me up inside was, would a judge see the farmland as historically significant and worth preserving, or would they side with the notion of progress? When the hearing day arrived, I stood in an intimidatingly formal courtroom, wearing my best collared shirt and a jacket that felt stiff against my skin. The HOA's legal team looked slick, shuffling through thick manila folders of evidence. Their main argument was that the farmland fell within newly approved zoning maps that the county had ratified. On my side, Roland argued that the original farm boundaries had never been rezoned properly. There was no legitimate documentation proving the farmland had been integrated into the new development. He also pointed out that I'd never signed any agreement to join an HOA. I could almost see the tension in the judge's furrowed brow as he listened to both sides. Ultimately, the judge granted a temporary injunction, halting the HOA's immediate activities. It wasn't a final victory, but it was a reprieve. That night, I sat on the porch with my father, both of us sipping lukewarm tea, reflecting on the surreal turn our lives had taken. The orchard glowed under a moonlit sky, and I felt the weight of uncertainty pressing down. We had another court date looming, one where the judge would decide whether the HOA's claim held legal merit or not. Yet, for the moment, I could breathe. No bulldozers would tear into the fields at dawn. The following weeks turned into a blur of depositions, document gathering, and overheard rumors. Roland discovered a possible crack in the HOA's argument. Their push to incorporate my land hinged on a county board vote that may not have followed proper public notice guidelines. It was a subtle procedural angle, but if proven true, it could invalidate the entire zoning shift that placed my farm under the HOA's umbrella. Each piece of evidence we gathered felt like a puzzle fragment. Maybe we'd reveal a bigger picture of corruption or shortcuts taken by the HOA. Meanwhile, I was terrified that if we failed to prove anything amiss, the county's updated map could serve as a rubber stamp for the HOA's takeover. Just as I thought I'd reached my limit, a local journalist, Jackson Price, called and asked if I'd be willing to speak on record. He'd gotten wind of a David versus Goliath story brewing, a family farm threatened by unstoppable suburban sprawl. Normally I'd shy away from public attention, but I realized that public opinion might be an asset. If enough residents understood what was happening, maybe the HOA would be pressured into backing off. Or perhaps a spotlight on their tactics would force local officials to question whether they'd allowed something improper. So I agreed. Jackson came out one afternoon, strolled the orchard with me, and asked pointed questions about my family's history here, our routines, and how the HOA's aggressive approach had affected us. I spoke candidly but avoided sensationalism. I simply laid out the facts. 2 days later, his piece ran in the local newspaper with the headline, "Historic Family Farm in the Crosshairs of New Development." It garnered more attention than I'd expected. Letters to the editor poured in, mostly supportive, some criticizing me for being anti-progress. Either way, the story was out there. The HOA responded by doubling down. Their president issued a statement claiming they'd reached out repeatedly to negotiate a fair agreement with me, an outright lie. They cast themselves as the altruistic developers of a needed community resource. My phone rang off the hook with local reporters wanting me to comment. I tried to keep my cool, focusing on the fact that we had a pending court date. Every day that passed felt like a countdown to a final confrontation that could decide my family's fate on this land. While rummaging through more of my grandfather's old papers, I stumbled across something that made my heart race. A letter from the state agriculture department dated the year I was born. It mentioned a preservation program that my grandfather had considered, one designed to shield farmland from commercial takeover. The letter wasn't a binding contract, but it hinted that he'd started an application. Had he finished it? Was the farm ever officially registered as protected land? If so, that would be the golden ticket Roland had been hoping for. I called up the state office, rummaging through automated menus, eventually landing on a bored-sounding clerk who told me the records were archived. She'd need time to dig up anything from that era. My nerves frayed, but I kept pressing. I don't know if it was fate or persistence, but a week later the clerk called back with an update. She'd found incomplete paperwork for our farm. My grandfather had begun the process, but hadn't completed the final steps. However, because the program was discontinued not long after, the partial application might still hold relevance, provided we could show an ongoing intention to keep the land strictly agricultural. This was a glimmer of hope, but it would require legal interpretation. Roland was cautiously optimistic. Any official record naming the farm as farmland for perpetuity, even if incomplete, might tilt the judge's sympathies in our favor. The next court session arrived quicker than I could mentally prepare. This was the big one, the hearing to decide whether the HOA had any legitimate right to impose its authority over my property. My father was too sick to attend, so he stayed home, praying for the best. I walked into the courtroom with Roland by my side, carrying a stack of documents that included the new find from the Agriculture Department. Across the aisle sat the HOA's team, confidently leafing through their binders. The judge, looking more tired than before, reminded everyone that the matter at hand was whether the farmland legally fell under the newly defined residential zone, thereby subjecting it to HOA governance, or whether it retained its independent status. The HOA's lawyer went first, presenting maps and amendments showing how my plot of land was now included in the county's updated plan. They made it sound so official, so inevitable. Listening to them, my chest tightened. Then Roland took his turn, methodically pointing out the questionable county board vote, the incomplete yet still telling agricultural preservation application, and the fact that I never consented to any association membership. He emphasized how the HOA proceeded with surveys, signage, and even threatened me with fines without any legal foundation. It was a masterful performance, measured and precise. Then came witness testimony. A county official testified for the HOA, insisting everything had been done above board. But, under cross-examination, Roland dug into the timeline of public notices. The official grew visibly uncomfortable, fumbling with dates. He finally admitted that the board might have accelerated certain steps to accommodate the new development schedule, though he refused to label it improper. Roland pounced on that slip, stressing how speeding through official channels was not just a technical detail, but a breach of proper procedure, effectively robbing the public, and me, of a fair chance to contest the rezoning. Next, I took the stand. My stomach churned as I answered the HOA's attorney's questions about how I maintained the property, whether I'd ever considered selling, whether I was open to reasonable negotiations. I repeated the same stance. This land was my family's heritage, a working farm, and I had no desire to see it turned into a clubhouse. My voice trembled a bit, but I forced myself to speak calmly and clearly. Then Roland guided me through our side of the story. The orchard's significance, my father's condition, the intrusive tactics of the HOA, and the incomplete farmland preservation application. I could see some members of the gallery nodding sympathetically. After a day of testimonies and evidence presentations, the judge announced he needed time to deliberate. My heart sank at the thought of more delays, but I had no choice. For 2 long weeks, I went back to feeding chickens, checking fences, and trying to keep the orchard free of pests. Every so often, a sense of panic seized me. What if the judge ruled in favor of the HOA? Would we be forced to watch bulldozers turn our orchard into a parking lot for a clubhouse no one had asked us about? When the ruling day finally dawned, I'd barely slept. The sky was overcast, a dull gray, as if mirroring my apprehension. The courtroom was noticeably full. Press, curious neighbors, and even a few members of the development who'd come to see how things played out. The judge read from a prepared statement, summarizing the key points. My pulse hammered so loudly I could barely concentrate on his words, but then I heard him say the HOA had not conclusively proven my property was lawfully under their jurisdiction. He continued, explaining that the county board's fast-track vote might be subject to further scrutiny. While he couldn't rule on the board's potential improprieties directly, since that wasn't the lawsuit's focus, he could rule on the HOA's claim over my land, and based on the evidence presented, he found no legal basis for the HOA to enforce its rules or break ground on my property. It felt as though the air rushed back into my lungs. I closed my eyes for a second, relief washing over me. The judge also lifted the temporary injunction and replaced it with a permanent order barring the HOA from trespassing on or developing my farm. If they wanted to challenge the county's zoning in the future, they'd have to do so through a separate legal process and face the possibility that their entire map might be invalidated due to questionable procedure. The lead counsel for the HOA looked stunned, while their president gave me a glare that could freeze molten steel. But I didn't care. The law was, for once, on my side. Outside, cameras flashed, and reporters bombarded me with questions. Roland stepped in to handle most of them, stating that justice had prevailed for now, and that my next steps would be to ensure the farm remained recognized as a standalone agricultural entity. I was too emotional to speak at length. All I wanted was to drive home, see my father, and tell him we'd won. Victory never tastes quite as sweet as you imagine, though. In the following days, I learned the HOA was filing an appeal, claiming the judge overstepped. Roland assured me that appeals were standard in big disputes like this, but he also believed we had a strong case. The media spotlight had forced local officials to investigate how that county board vote was conducted. Rumors swirled of backroom deals and unscrupulous permit approvals. If any of that turned out to be true, the HOA's position would only weaken. For the time being, though, they remained determined to keep pushing, presumably hoping their deeper pockets and relentless legal strategies would wear me down. The farm itself felt lighter, as though nature was exhaling relief. I caught glimpses of new wildlife near the creek, and the orchard produced a surprisingly abundant harvest that fall. Friends and family gathered for an impromptu cider pressing party, celebrating the orchard's sweet gifts and the recent courtroom triumph. Through their laughter and warmth, I realized something important. This fight wasn't solely about property lines and legal technicalities. It was about preserving a way of life, a connection to the land that many big developments overlook or outright dismiss. Still, the threat loomed. Clara reminded me that an appeal could drag out for months, maybe years. But now that the community was aware of the situation, I felt less alone. A small group of local farmers formed a coalition aiming to protect each other from potential land grabs in the future. We shared legal resources, swapped stories about how these HOAs operated, and pledged to stand together. The story that Jackson wrote became a reference point for other families who felt pressured by bigger entities. On social media, the hashtag #SaveOurFarm trended locally for a while, fueling public dialogue about farmland, zoning laws, and the ethics of expansion. The HOA, meanwhile, tried a different tack, a charm offensive. They hosted open houses, praising community values, featuring a proposed design that claimed it would honor local history. I was invited, via a very formal email, to attend a panel discussion about collaborative land use. Roland advised against it, suspecting they might twist my words or use the event to portray me as uncooperative. I heeded his caution, politely declining their invitation. In their promotional materials, I noticed they conveniently omitted the fact that a court had already ruled in my favor. Instead, they spoke about the clubhouse as if it were still a done deal. Perhaps they believed that if they kept selling the dream to their residents, they could build enough public pressure to force me to negotiate. On a more personal note, my father's health continued to decline. Some days he was coherent enough to chat about the orchard or ask if the roosters were still crowing at dawn. Other days he'd drift in and out of sleep. I often worried that the stress of this legal battle might be shortening his time with me, but every time I mentioned worry or guilt, he shook his head. "You do what you have to do," he told me. "We keep the farm safe for the next generation." With that encouragement, I soldiered on, determined not to let the HOA scare me into surrender. Our next big legal milestone was the appeal hearing. This time, the county's involvement took center stage. A panel of judges would review whether the original trial judge had applied the law correctly. Roland filed a strong brief, emphasizing that my property rights should never have been in question, and that the evidence of improper zoning procedures was credible enough to justify the initial ruling. The HOA responded with their own brief, claiming the judge was biased and ignoring the greater good of the community. Reading their statements made my blood boil. They painted me as an obstructionist who refused to engage in a constructive dialogue. My frustration grew, but I also steeled my resolve. If they wanted to keep twisting reality, I'd just have to trust the law to see through it a second time. Unlike a trial, the appeal hearing wasn't about calling witnesses or presenting fresh evidence. It was mostly about legal arguments. The room felt more clinical, the atmosphere more restrained. I recognized a few faces from the HOA's side. Their expressions were guarded, less sure than before. The appellate judges peppered both lawyers with questions about procedural fairness, historical land rights, and the extent of an HOA's authority over farmland. I held my breath with each exchange, scanning for hints of which way they might lean. Roland seemed in command, referencing cases from other districts, citing legal principles that favored property owners in disputes involving forced annexation. The hearing wrapped up in under 2 hours, and we were told it might take a month or more for a written decision, another limbo. I tried to distract myself by plunging deeper into farm work, harvesting apples, winterizing the barns, checking soil quality in the outlying fields. As cold weather crept in, I felt the knot in my stomach tighten. Would we spend the holiday season still wondering if the HOA could overshadow the lower court's verdict? On a chilly afternoon in late November, the decision arrived by mail. Roland phoned me as soon as he received it. My hands trembled opening the envelope. The appellate court upheld the original ruling. There it was in black and white. The HOA had failed to prove any legal right to take over or develop my land, and the judge had acted within his authority. The farmland was officially off limits to them unless they pursued an entirely new zoning request, and that would require a legitimate, transparent county process that was unlikely to succeed now that the public eye was squarely on them. I sank onto the porch steps, tears blurring my vision, the crisp air biting my cheeks. It was done. We'd won at the appellate level. I could almost feel my father's relief from inside the house. The next day, local papers picked up the story. Appeals court backs family farm. Online, supporters cheered, and the HOA's leadership went quiet. Any mention of the Harvest Hills Clubhouse project disappeared from their website. Construction vehicles that had loomed near my boundaries rumbled away. In the aftermath, I learned the county board initiated a review of their own processes, likely to prevent further scandals. A couple of board members quietly resigned. Rumors suggested that the HOA's board president might also step down, having burned too many bridges with the failed campaign. Meanwhile, offers started trickling in from local businesses and individuals who wanted to partner with our farm, some to purchase organic produce, others to use the orchard for seasonal events. It was a refreshing change of tone from "we're taking your land" to "how can we collaborate?" Life settled into a new normal. I finally had time to focus on renovating the barn and upgrading our irrigation system, tasks I'd put off during the legal chaos. My father's condition fluctuated, but we shared a quiet satisfaction that the farm's future was secure. Even the orchard seemed more vibrant that spring, blossoms bursting with color as if celebrating the land's reprieve from suburban takeover. Clara joked that I should create a t-shirt, "I survived the HOA." We both laughed, though a part of me still felt the scars of the stress. But those scars came with valuable lessons. That it's crucial to know your rights, to stay vigilant against overreach, and to remember the power of community support when facing a well-funded adversary. A few months later, Jackson Price checked in for a follow-up story. He wanted to capture how the farm had fared post-lawsuit. I walked with him among budding apple trees, explaining how victory had breathed new life into our family business. It wasn't just a court case, I told him. It was about preserving a piece of heritage that can't be rebuilt once it's destroyed. He nodded and took notes, occasionally snapping a picture of the blossoming orchard. Later, his article painted the farmland as a symbol of resilience in the face of unchecked development. The local response was overwhelmingly positive, inspiring other small landowners to stand up for their properties. Of course, the HOA still existed, but their ambitions had noticeably shrunk. They focused on improvements within their already established boundaries, minor beautification projects, a modest park, stricter guidelines on house colors for their own residences. Word on the grapevine was that their membership had become divided over the disastrous legal battle. Some members blamed the board for wasting funds. Others still harbored resentment toward me for ruining their clubhouse dream. I let it go. Life was too short to dwell on bitterness. It was enough to know that they couldn't step foot on my land without permission ever again. Season by season, the farm continued to blossom. We experimented with different apple varieties, started a small pumpkin patch, and even hosted a fall festival for the local community. Everyone was welcome, including neighbors from that new development. Some of them came, curious to see the farmland they had once been told would be a future clubhouse site. Surprisingly, they admired the orchard and barn, jokingly admitting they were glad it hadn't been paved over. They marveled at how close farmland and suburban life existed side by side. Standing among the pumpkins and hay bales, I felt a sense of closure. The hostility was gone, replaced by a cautious acceptance, even respect. Shortly after that festival, on a crisp autumn morning, my father passed away peacefully in his sleep. I found him in his chair by the window, a gentle smile on his face. The funeral was small, just family, close friends, and a few local farmers who'd known him for decades. As we laid him to rest on a gentle slope overlooking the orchard, I felt an ache that words couldn't express. But there was solace in knowing I had fulfilled the promise to keep our land safe. In a way, his final days had been eased by the knowledge that we wouldn't lose the farm. It would remain a testament to our family's dedication and the legacy he'd nurtured. That winter, everything was quieter. Snow blanketed the orchard, and the barn glowed warmly from within as I fed the animals each morning. My grief was still raw, but it mingled with gratitude for the farm's enduring presence. Neighbors stopped by with casseroles and well wishes, reminding me that community wasn't limited by property lines. Through their kindness, I realized that despite the battles we wage, legal or otherwise, people are capable of coming together in meaningful ways. Spring returned with the sound of melting snow trickling through the fields, new buds forming on fruit trees, and the renewal of life. Freed from the burden of lawsuits, I poured my energy into improvements. I collaborated with an agricultural extension program, hosting workshops on sustainable farming. We revived a seasonal farm stand that my grandfather had built decades ago, selling fresh eggs, apples, homemade jams, and honey from our own beehives. The local turnout was heartwarming, proof that supporting small-scale agriculture wasn't just a nostalgic ideal, but a tangible choice people were eager to make. Now and then I'd see a meeting notice for the HOA pinned at the local grocery store, but I never paid it much attention. Their leadership had changed. The community center they originally wanted had been downsized to a modest building within their subdivision's own boundaries. In reflecting upon it all, I recognize a fundamental lesson. Land isn't merely about acreage or monetary value. It's about identity, memory, and culture. Large organizations, be they developers, corporations, or HOAs, often view property through the lens of profit or communal features. But a farm like ours embodies generations of dedication and a living narrative of how families sustain themselves off the land. Once that is bulldozed, it can't be replaced. Standing up for such intangible qualities might seem daunting, especially when facing institutions with powerful lawyers and deep pockets. Yet the spirit of resilience can manifest in unexpected ways, through supportive neighbors, ethical lawyers, honest journalism, and even conscientious judges who interpret the law with fairness. Looking back, I see how close we came to losing it all. If I hadn't made calls, hired Roland, or found that partial preservation application, the farm might have been consumed by a labyrinth of asphalt and concrete. The orchard would have become a row of tennis courts, and our barn relegated to some historical placard. But I found my voice and discovered that you don't have to stand alone. Everyone who donated time, advice, or moral support became part of our victory, and that victory reverberated, encouraging others to scrutinize zoning changes, ask hard questions, and resist blindly following HOAs that overstep their boundaries. Today, the orchard is an idyllic escape. People swing by to pick apples, wander among the blossoms in spring, or sip hot cider in the fall. Schools bring children on field trips, teaching them that apples don't just appear in grocery aisles, they grow from trees nurtured over years. I've started journaling my family's story, how my great-grandparents first tilled this soil, how my father improved the orchard, and how we nearly lost it to an overzealous HOA. I plan to pass that journal on to my own children someday, so they understand the importance of tending both the land and the legacy tied to it. I won't pretend everything is perfect. Farming remains a gamble with weather, pests, and market fluctuations. Some seasons we barely break even, but no matter how tight the budget gets, I step outside at dawn and see the sun cresting over fields that are mine to preserve. I breathe air perfumed by damp earth and blossoming trees, hearing the hens cluck contentedly as they peck at the ground. In these moments, I remember that not all rewards come with dollar signs. Some come with the knowledge that you defended something priceless against overwhelming odds. Whenever I recount the story to visitors, I end with the same reflection: don't underestimate what can happen when a powerful group thinks your land belongs to them. But don't underestimate your own ability to stand up for it either. It resonates with people who faced property disputes or who fear losing their homes or traditions to relentless expansion. They often ask if I have any regrets. Truthfully, the only regret I have is not acting sooner, not realizing how serious the threat was until the surveyors started hammering stakes into the ground. Yet perhaps that was part of my learning curve, understanding that rights and heritage aren't guaranteed. You must remain vigilant if you want to keep them intact. The orchard is in full bloom right now, a sea of pinkish-white petals trembling in the breeze. From my porch, I can see honeybees busy at work, drifting flower to flower. I recall the day I nearly lost this view to a corporate playground masked as a clubhouse. Now, the farm remains an oasis of authenticity, a place for animals to roam, children to explore, and neighbors to gather for harvest festivals. Best of all, it stands as a reminder that sometimes, just sometimes, the underdog wins. In that triumph lies a piece of wisdom I hope all who hear this story will carry. When you find yourself in a battle for what's rightfully yours, your home, your legacy, your sense of belonging, courage and solidarity can be more potent than any legal advantage the other side wields. You may need lawyers, you may need allies, and you'll definitely need perseverance. But if you remain steadfast, even the best-funded adversaries might discover they picked a fight they cannot win. My farm still stands, and with it the promise that no matter how imposing the forces against you, standing your ground can preserve a piece of the world that truly matters.